Welcome to our 7th lecture covering the topic of the nature of the employment relationship. We're going to just backtrack for a second and see where we've been. We covered a brief introduction to the course, and we spent a lot of time talking about the worker as either an employee or an other category, usually being independent contractor. Then in our last lecture, we talked about the business. How do we define employer? And when the person isn't an employer but is a principal instead, what impact does that have? And we looked at we considered some statutory differences with respect to how employer is defined. Our last topic is about when the employment relationship is over. How does that change the relationship? You might say, well, if it's over, it's over. But kind of like when you have a divorce, it's not like you've never been married to that person from a legal perspective, or at least in many cases it's not that way. And so there does continue to be a relationship in some cases, even though the employment relationship is no longer in force. And so we're going to talk about that primarily in the context of non-competes. So let's begin. First of all, you may not have heard the term non-compete or non-competitive agreements before. It's something that doesn't happen in all industries commonly, and it doesn't happen to most employees, even in industries that use non-competes. But especially in the high-tech field or in creative fields, they are fairly common. You see them a lot in the hair styling industry. For whatever reason. So high-tech and hairstyling seem to have a lot of non-competes. It's also kind of a business model issue. You'll see some companies in an industry really, really love non-competes, and others in that same industry don't use them at all. So it can really vary greatly as to whether you'll be seeing these commonly in your practice. So what is a non-compete? Again, here we have another word that you're going to want to add to your Quizlet. And again, here we have the definition. And here's the definition that I've selected for non-compete. It's an agreement between the employer and the employee in which the employee agrees not to discuss the employer's confidential information or enter into competition with the employer for a specified period of time and or within a specified region. Non-competes are colloquially referred to as non-competes, but they are technically a non-compete agreement or non-compete contract. Another term for it is covenants not to compete. You'll see both of these terms very commonly. One of the reasons why they're called covenants not to compete is it's usually part of a larger employment contract document. So one of the things about non-competes are that they vary greatly in terms of their enforceability in the different states. And certainly from an international perspective, you would really need to take the idea of non-competes with a significant grain of salt to make sure that it actually is going to be enforceable in whatever jurisdiction you're thinking about applying it. I like to think of the non-compete situation as a continuum. We have over here California. And California won't allow any non-compete to be in effect, and in fact won't enforce a non-compete from another state. It has the most anti-non-compete position out there. Many people think that's why Silicon Valley exists. Because of the lack of non-competes, engineers and computer science whizzes can jump from one company to another and start their own company and then jump to something else without having any limitations on their movement. And so some people see that as a good thing. Other people see that as the capital, the human capital that a company has worked very hard to develop is walking out the door, almost like the computers or the other material that business has been developing. It's walking out the door and the company can't do anything to stop it. So that's one extreme, California. You have other extremes. I'm going to use the example of Kansas, but there's many states in this category that will enforce most non-competes. In fact, I would say they enforce a very significant number of non-competes. The philosophy in that state is If both parties want to enter into the agreement and they sign on the dotted line, who are we to be the nanny state and to tell them that the two parties can't enter into an agreement that they find advantageous? So there's also a lot of states kind of in this range. California is a little bit of an outlier. There's not a lot of states that are as close to California as states are in this area. But there's a lot of states that will enforce a lot of non-competes, but they're also a little bit suspicious of them because they recognize that there can be unequal bargaining power. You may recall, I believe in our first lecture, we talked about some of the reasons why we have regulation in all of the employment relationship. And one of the reasons we identified was that there is unequal bargaining power in many situations. Well, oftentimes non-competes arise when a person is already an employee. And so if you're already an employee and your boss comes in and says, sign this or you're out of a job, many of us would be inclined to sign it even if we didn't think it was in our best interest, because it's hard to find a job when you don't have a job, right? And you may not be able to go a period of some time, maybe weeks or even months before you can find that next job. So you are in a position of less bargaining power at that time than perhaps if you hadn't been employed at the time and it was explained to you, hey, if you accept this job, you're going to have to sign a non-compete. That seems like a more equal bargaining power. So Texas is kind of here in the middle. We are more reluctant than many states, I would say most states, to enforce non-competes. But that has changed pretty significantly. If you were taking this course 15 years ago, I would have said we're pretty close to California. We didn't enforce very many non-competes at all. In theory, you could do it, but it seemed like courts were always saying, yeah, non-competes can be enforceable in Texas, but we don't like this one, and we're not going to enforce it. But they can theoretically exist. We've just never seen one that worked. But over the last 15 or, I'd say 15 years, the courts have moved slowly towards a pretty mainstream perspective on it. So I would put us kind of in the middle of this continuum. And the change hasn't come about because of a change in the statute. We'll look at the statute in a few minutes and we'll see that it's a pretty standard statute in this area. It's neither extreme like California nor perhaps as open to enforcing everything that comes down the pike as Kansas might be. But initially, the Texas Supreme Court had a very wary concern about these. And so they perhaps interpreted it in a more narrow way than the legislature had intended. That's my opinion. I could be wrong, but that I think would be most people's take. And then when there were changes to the composition of the Texas Supreme Court, and as you probably know, it is an elected court, and sometimes people leave. For example, John Cornyn, our senator, was on the Texas Supreme Court, and there have been other members of the Texas Supreme Court that have gone on to other roles and have retired or other things along the line. And so we have seen a change in the composition, and the current composition is much more open to enforcing. They're not going to enforce anything that isn't reasonable, but they are willing to enforce agreements. And probably they're willing to enforce agreements that 15 years ago wouldn't have been enforced. Here's a link to the statute, but I'm going to show the statute to you on the next slide. I've also posted it on Canvas, so you can look at it there. This actually isn't the complete statute. There's additional sections primarily dealing with medical professionals. So we're going to start right here looking at from this section on to this section. A covenant not to compete is enforceable if it is ancillary to or part of an otherwise enforceable agreement. So let's just pause there. So we can see that the covenant not to compete has to be part of a larger document. So this is one section of it. And many times it will be literally part of that bigger document. But it's also okay if there are two documents one being the covenant not to compete and the other being the contract, but they refer to each other and they're definitely tied together. That would be the ancillary situation. But again, probably the cleaner way is to actually literally put it inside the document. So a covenant not to compete is enforceable if it is ancillary to or part of an otherwise enforceable agreement at the time the agreement is made. Okay, so this would be probably our first requirement. So I'm going to call this number 1. So we see that we need an otherwise enforceable agreement, and we need this covenant not to compete to be a part of it. And that the covenant not to compete has to be entered into at the same time that the agreement is made. Okay, so this was the part that the Texas Supreme Court was constantly saying back in the 2000s or the early 2000s. Oh, yeah, it could exist, but this isn't it. This particular covenant somehow fails part of this equation. It's not truly ancillary, or the underlying agreement is enforceable. The next part, courts really didn't spend as much time on because they could, the employer couldn't figure out a way to persuade the court to enforce it based upon part number 1. Let's go and look at part number 2, because as I say, it's not automatic that you're going to find you comply with part number 1, but it's now a more achievable goal. So let's assume for the sake of argument we're the employer, we've satisfied this first element. So now it has to contain the limitations that it contains as to time, geographical area, and scope of activity to be restrained are reasonable and do not impose a greater restraint than is necessary to protect the goodwill or other business interests of the promisee. In this case, the promisee, think employer. I use the ER for employer. So it has to be reasonable in 3 areas: time, geographical area, and scope of activity. So what is reasonable? Well, it's a case-by-case analysis, but I'm going to give you some rules of thumb. Usually the time period starts ticking when the employment relationship ends. And usually about 2 years is considered reasonable. Now it's going to vary to some extent based upon what we're talking about. There could be some really high-tech industries where technology that is known about on January 1st, 2022 would be ridiculously out of date by January 1st, 2024. 2 years is just way too long to expect that cutting edge technology to be of any utility at that point. Another example would be in the hairstyling industry. I would argue that 2 years is too long for that, because a person, except maybe during the COVID-19 pandemic, is going to get his or her hair cut probably several times a year. If a person goes 2 years between haircuts, they're probably not going to be a regular customer of a hairstylist. And so the idea is, if I have been styling Bob's hair at a salon in which I'm employed, and I get out of the hairstyling business for a year, in that year, Bob has had to go somewhere else to get his hair styled, and probably has gone to that same new stylist several times, or gone to several different stylists several times. And so his connection to me has at least temporarily been severed, just because of the nature of how hair grows. So some industries, it makes a lot of sense to have a shorter period of time than 2 years. There could be other industries where 2 years is too short. For example, let's say that I work for John Deere and I sell tractors. Well, and I go to farmers and try to persuade them to buy my tractors. Well, a farmer isn't buying a new tractor every 2 years. Very possibly he or she only looks to buy a new tractor every 10 years or 15 years. And so my database of farmers and the relationships I've developed with those farmers would still be a meaningful lead 5 years or more after the date that I have ceased to be an employee. So 2 years is generally considered a pretty good rule of thumb. For some industries, maybe a little less. I think, though, you'd be hard to persuade a court to enforce much longer than 2 years, possibly 3 years, but they're not going to enforce a 10-year period of limitation. So 2 years is probably a good rule of thumb. But again, it's all going to turn upon the business model that we're looking at. The next area is the geographic area. Many times non-competes are designed to address a salesperson. A salesperson has some insights to his particular company's product, and if he goes to work for the competitor, he can then say to the customers, hey, I used to work for that company, they offer terrible customer service, or their product is a bunch of garbage. And then, of course, that salesperson also has all of those leads that he developed when he was working for that other employer. So usually what happens when you're talking about salespeople is that the geographical area that that person had his sales territory or her sales territory is the limits of what you can exclude that person from working in. So let's imagine that I am, again, a tractor salesperson, and my territory is the eastern half of Texas, Louisiana, and Oklahoma. Well, that would be the proper limits to my non-compete. It might be that I share some information with some of my colleagues who have the western half of Texas and maybe New Mexico. So it's possible you can make an argument for somewhat of a greater, broader jurisdiction if I work with other people who happen to have other territories. An argument could also be made if I've also covered those areas from time to time during my employment. But generally, you're going to see the geographical area matching up. If we're talking about high tech, we're probably looking at a worldwide geographical area, because obviously if I develop a new technology for a cell phone, presumably that technology will work in Japan as easily as it works in Frisco, and it'll work in Chile as easily as it works in Washington, D.C. So geographical areas don't make a lot of sense in the high-tech area. Let's go back to the hairstyling situation. If I'm a hairstylist, unless I'm a super famous one who styles the hair of stars, most likely people aren't going to travel more than 20 miles to get their hair styled by me. If in that situation, if I am moved to a salon that's, say, 25 miles away, it's very likely, unless this person is my very good friend or a family member, that they're going to say, I don't want to travel that far to get my hair styled. I'm going to go ahead and get a new stylist. So oftentimes for services like that, a 25-mile range to the limitation can make sense. If it were a more expensive salon, maybe you could justify 50 miles. But certainly a statewide limitation for a stylist would be very unusual, unless you're talking about a state like Rhode Island or something. The scope of activity. This can be a source of interesting issues, perhaps even more than the first two areas. Imagine that I'm a stylist and I specialize in hair coloring. That's my niche. And in fact, not just hair coloring, but I specialize in kind of fun and playful colors, pinks and blues and purples, and lots of different specialized kind of treatments that cause the hair to kind of make a statement. And I decide to leave my place of employment, or my employer recognizes that this is kind of my niche, and so he might or she might want me to sign a non-compete that limits me from doing hair coloring. But he or she might also say, well, you also are licensed to do hair cutting, you're licensed to do perms, you're licensed to straighten hair, for example. You can do all those things. You don't commonly, but those are things within your licensure. And so I want the non-compete to cover not just what you do here, but what you possibly could do. But if I truly don't do those tasks for you, even when I'm coloring the hair, I don't say, oh, well, let me trim your bangs too. Or, well, let me give your hair a bit of a perm. If I don't do that, if I literally only do the hair color, then under those circumstances, you would say that the scope of activity ought to be limited to what I actually do. Now, maybe I color hair, and that's why people come to me, but after all, when they're in there getting their hair colored, they may say, you know what, could you take an inch off, straighten up my edges at the ends of my hair, or something along those lines. And so occasionally, maybe 5 or 10% of the time, I do a little bit of cleaning up there, but nobody comes to me for that purpose. Well, that could be a more ambiguous situation. It's certainly possible that there could be an argument that is within the scope of my work, and so it could be included in the scope of activity. Again, that would be a gray situation. So exactly what the scope of the job is and what I do versus what I do now versus what I might do in the future. And of course, when you sign a non-compete, positions evolve over time. Maybe people stop liking the fun, playful hair colors and they want permanence. That maybe becomes a big deal. Well, probably I'm going to change my business model. I want to get customers, so I'm going to say, hey, yeah, let me refresh myself on correct perm techniques, and I'll start doing perms. Well, in that situation, a lot of times the non-compete doesn't get revised. People don't think about it. Plus, they don't have an attorney on staff to micromanage all of that. So sometimes the salon might say, well, we have a broad non-compete that covers a lot of different stylists. And so we recognize that positions evolve over time, customers' tastes evolve over time, so we want a broader term. I could see a court saying that seems reasonable given the fact that these are relatively small businesses. Maybe makes sense to have having all of those positions covered. But let's think for a second. Let's say that we are a salon business and we have a very employee-friendly non-compete. We only have it be 6 months, and we restrict the area or the range to 25 miles, and we limit the scope of that. And let's say our stylists really are Jacks and Janes of all trade. They cut hair, they perm hair, they style hair, they dye hair, they straighten hair. They do it all. So it's all of the styling techniques. And because everybody does them all, it would be a reasonable scope. So let's say I'm a stylist and I earn about $30,000 a year. And as I've worked in this salon, I've built up my book. That's what it's called, the list of customers that you have. And obviously you start out mainly getting walk-in customers. But over time, you attempt to persuade these customers to kind of be loyal to you and to always schedule to meet with you. And then over time, you are accepting fewer and fewer walk-ins, and you are having this book, this list of customers that you can count on. And before they leave, you go ahead and schedule their next appointment and all that kind of stuff. So maybe you start out earning, we'll say $20,000 a year, but as you build up your book, and you also encourage your customers to take on more services. Hey, maybe they come in to get their bangs trimmed, but you suggest, why don't we put some highlights in your hair? And then the next time, why don't we put some more color in your hair, not just highlights, but also a more complete color job. Or maybe you need a permanent, or maybe you ought to buy some hair products. All of those things. So there is an increase in the volume of business that this person is doing. So now they're earning $35,000. They decide that they want to maybe start their own salon, or maybe go to work for another salon where they can maybe give less of the money to the management that runs the salon. And so they pack up their bags one day and say, I'm out of here. And of course, they're taking that book of customers with them. But unfortunately for that stylist, this particular stylist has already signed a non-compete. And so the day she leaves and goes to work for the other place, the owner of her former salon calls an attorney and says, write me up a letter to enforce this non-compete agreement. And so the attorney writes up the letter, sends it to the new salon. The new salon sees, oh, I'm going to be sued. I mean, I wanted to have Susan, my new stylist, style hair, but I can't afford to hire an attorney to handle this matter, so I'm going to have to let Susan go. And so now Susan is out of work, and in fact, she discovers wherever she applies, let's assume it's a relatively small community, nobody's willing to touch her, or if they do hire her, once they get the letter from the attorney, they're not willing to continue her employment. Well, Susan's not a wealthy person. She was earning $35,000 a year. She's got bills to pay. She's not going to be able to last for 6 months without having a paycheck. I mean, yes, I guess she can work for McDonald's flipping burgers, but that's not what she wants to do for her career. And keep in mind that in 6 months, many of her customers will have found other stylists to do their hair. So if she started at $20,000, she built it up to $35,000. In 6 months, she's probably going to be down pretty close to the $20,000. She will have lost that income. So you can see in that situation, if Susan knows how this plays out, she's not going to really feel free to leave her first place of employment. She's almost a hostage of that place of employment, because if she leaves, she's going to have to enter a different industry, at least for some period of time. And yes, she can go to another community and start her salon there, but again, she'll be starting from scratch. She won't have that following that she will be able to use as a customer base. So what happens sometimes is that the current employer, the one that required Susan to sign the non-compete, then starts making some changes once the non-compete is signed. Maybe it requires, instead of 50% of whatever Susan takes, maybe it starts requiring 60% of whatever Susan takes in. Or maybe it makes Susan work hours that she doesn't want to, or do other tasks that she does prefer. And so she's thinking, well, I don't want to do this. Well, maybe she doesn't, but it's hard to see how she can leave and stay in this industry. So you can see again that idea of almost being a hostage to the place of employment. And that's one of the potentially unfair aspects to the non-compete. It can serve legitimate business reasons. After all, Susan didn't get all these customers completely on her own. Many of these customers were walk-ins to the salon, and they didn't even know Susan before the first time Susan cut their hair. So it makes sense in some sense to think about Susan's book being not just her book, but also the book of the salon. But you can see how it doesn't seem completely fair. It's especially may feel unfair when you consider that the non-competes are usually enforceable even when the salon itself has fired Susan. It has decided that Susan is not a good fit. Maybe she's not performing the services that the manager wants. And if it wants to let Susan go, Susan is still going to be bound by these limitations in the non-compete. So you can see how, you can kind of see the logic behind why California doesn't enforce these. Of course, you could flip it and look at it from the other side too. Let's imagine that Susan comes to work without having any book there. All of the customers she gets because of the excellent advertising and excellent reputation and fine appearance and location of this salon. And if she then takes those names and goes to another salon, all of that hard work that that salon owner has done and all of that financial investment is gone, poof. And so you can see both sides of the equation from that perspective. So non-competes can be a fair and reasonable tool, or they can feel pretty unfair. Anyway, let's move on. Covenant not to compete provides for a certain time that the employee will not compete with the employer within that industry. It must protect a legitimate business interest without restraining market competition, and it must have reasonable terms. Again, these are things that we've already covered. Of course, these are all restraints upon trade. So they have, non-competes have some antitrust aspects to them, and we know that trust, the monopolization of resources is not an economically efficient solution, and when it's carried to an extreme, it can actually be a violation of the law. And so you have to balance that. People being tied to a particular place of employment and not being able to leave is not a good thing generally. On the other hand, it's not a good thing for workers to be able to leave with trade secrets and other information and use that information against their former employer. So there's definitely a balancing act. Now, we've talked about how these agreements vary greatly from state to state. In California, they're just not going to be enforceable at all. In other states like Kansas, I think Connecticut's another one, they're quite easily enforceable. So one of the things you're almost certainly going to want it, and most likely you're going to be representing the employer when you draft these types of agreements, because the employer is the one that prepares them. The employee obviously wouldn't be interested in preparing a non-compete. So if you're working for the employer, you're going to want to have a form selection clause in the contract. You're probably going to want to have that even in Texas, because a person who, unless the geographical area is very small, because then it would be obvious it would need to be Texas anyway, but if you had a broader one, and let's say your employee ended up moving to a state that had a more narrow interpretation of which ones are enforceable, then you could say, well, the state law in your state shouldn't be the standard. It still ought to be Texas. And as I said, Texas tends to be a more pro-employee state in this area. So it's not an especially good place for the employer. But usually if you're a Texas employer hiring a Texas employee to work in Texas, you need to pick the state where all those things are happening. If one piece of that equation is in another state, you might be able to make an argument that another form could be appropriate. I think I said before, but let me reiterate. California will not enforce a form selection clause. Now, a Texas court very likely would enforce a form selection clause. So, for example, let's say that you work, your client is a multinational corporation with locations throughout the United States, and it is choosing to hire somebody who currently works in Kansas. And this person is going to be based in Texas, maybe, or maybe not. And so you know that Kansas has a very open and flexible ideas about non-competes. And so you would very likely choose that state for the form selection clause. Let's say that you draft an especially aggressive, based upon the client's preferences, you draft an especially aggressive non-compete that you recognize probably a Texas court would say that's not good. But the Texas court isn't going to be applying Texas law if you've chosen Kansas as your form selection location. And so then the Texas court's going to say, well, what does Kansas law say? Oh, Kansas law seems to be cool with this. And so that means that you don't have to worry as much about the way that Texas are going to enforce it. This isn't going to help in California because California is going to ignore the form selection clause, but most jurisdictions are going to comply with that. Okay, so we've kind of already gone through this language. This is not really directly related to non-competes, but this is prohibited. Companies cannot enter into agreements with other companies to not hire each other's workers. You know, just say, okay, if you don't want, I won't steal your workers if you don't steal my workers, that type of thing. That is an antitrust problem. That has nothing to do with non-competes, except, I guess, in some sense, the companies, the employers might enter into non-compete with each other. It's a good idea to not just have a non-compete, but also to include in your non-compete a non-solicitation of customers or suppliers and agreement that you're not going to try to get, try to use that new employee that you hire, or prohibit your current employee who leaves your employment from soliciting the employees who are still with you. And all of that is pretty common boilerplate stuff you're going to see in non-competes. If the non-compete is inherently enforceable, that should be okay as well. Okay, now we're going to flip gears and talk about trade secrets. Again, this is another vocabulary term, and here's our definition. A trade secret is a secret. It has to be maintained as a secret. Like KFC's 11 herbs and spices, or the formula for Coke. Those would be examples of trade secrets. They're things that aren't generally known, but that have a value, and that the company is working pretty significantly to protect it. Examples of trade secrets obviously can be technologies or recipes, but it can also be things like customer lists or future marketing plans or things like that. Many times trade secrets are the reason why we have the non-competes. After all, if I am the senior person at Coca-Cola and I happen to know the formula for Coke, well, you can see how Pepsi might want to hire me. And so I would very likely be required to sign a non-compete before I was given access to the formula, so that I couldn't take advantage of that secret knowledge that I have. Sometimes we use non-competes in that situation, but another tool that's available, and it can be used with a non-compete or it can be used separately, would be a non-disclosure agreement. NDAs are oftentimes what they're called. And these are designed to stop the information from flowing. And it means that that employee has the responsibility to keep that information confidential even after he or she is no longer employed by the company. And he or she has to keep the secret as long as the company keeps the secret. So again, if I'm an executive at Coke and I find out the secret formula for Coke and I leave Coke, as long as the secret doesn't come out, I'm going to have to keep that secret for the rest of my life, even though Coke isn't giving me any more money, right? So a non-disclosure agreement, and I guess this should be in red. This is another vocabulary term. Maybe I have it on the next slide. I don't have it. So let's talk about something that's going to feel probably to most of us pretty unfair. And this is a doctrine called the Inevitable Disclosure Doctrine. Excuse me. And this is another vocabulary term, so be sure to add this to your Quizlet list. So what is inevitable disclosure? Well, disclosure is when a secret comes out. And sometimes it seems pretty impossible for a secret not to leak. Now, I don't mean in this context that people just can't keep secrets and people are prone to gossip. That's not what makes it inevitable. Let me give you, we'll talk about the Redmond case in a couple minutes. That gives you a good example of it. But let's talk about the definition for the inevitable disclosure case, and then we'll talk about Redmond. This is the theory under which a court may prohibit a former employee from working for an employer's competitor if the employer can show that it is inevitable, meaning it's for sure to happen, that the former employee will disclose a trade secret by virtue of his or her new position with that employer. So you can see here that the old employer is getting the benefit of a non-compete without ever requiring the employee to sign on the dotted line. It gets a non-compete, but it didn't have to negotiate a contract with the employee. So it's a pretty kind of sobering turn of events. Now I'm going to tell you that usually the inevitable disclosure doctrine only comes to play with relatively senior executives, because courts understand, well, if you wanted a non-compete, you should have negotiated. The employer, if you wanted a non-compete with this person, you should have negotiated it. I'm not going to give you something that you aren't clever enough to negotiate for. So again, the employers are protected against disclosure of trade secrets even if there is no NDA. A court may prohibit a former employee from working for an employer's competitor if the employer can show there is an imminent threat that a trade secret will be shared. So let's look at, actually, let's go ahead to the Redmond case, and then we'll backtrack and talk about the other items that we have here. So the question is, should an employee be enjoined? And you may have heard the word let me just type this up here. Word injunction you may have heard. And that's related to the word enjoin, even though injunction starts with an I instead of an E. But should an employee be enjoined? In other words, should a court stop the employee from working for a competitor when it is a competitor of his current employment, when it is reasonable to assume that the trade secrets of the former employer will be inevitably disclosed to the new employer? And the answer can be yes. So let's consider the circumstance. Redmond worked for PepsiCo for 10 years. He had a very high position within that company, and he signed a confidentiality agreement with Pepsi. That isn't necessarily dispositive because employees are assumed that they're going to keep the secrets of their employers, so duty of loyalty. But the fact that he actually signed the confidentiality agreement is a good fact for Pepsi, but it's not dispositive. Okay, so the agreement said that Redmond would not disclose at any time or make use of confidential information Scott from Pepsi. And time passed and Redmond accepted a job with Gatorade. Now at that time, Gatorade was a competitor of Pepsi. Later on, Pepsi buys Gatorade, which is kind of interesting. But at the time that the relevant events happened, Gatorade was a competitive product. Of course, PepsiCo doesn't own just Pepsi. It has lots of different beverages, some of which I think it owns Powerade, or at one point, or was developing its own version of Gatorade. And so it was in that market. So when PepsiCo finds out that Redmond, its executive, who knows a lot of its business models, it seeks a TRO, temporary restraining order. We'll talk about what that is in a couple of minutes. But it's a mechanism to stop Redmond from being able to go to work for Gatorade, and to prevent him from disclosing the trade secrets. So let me just talk about what a TRO is. So TRO stands for temporary restraining order. It is a special type of injunction. We talked about the word injunction here. Injunctions often follow three phases. We have the TRO phase, then we have the preliminary injunction phase, and then we have what is sometimes called the permanent injunction or just the injunction phase. And the TRO happens really quickly. It's when something pretty awful is about to happen, and in days, sometimes hours, are going to make a difference in whether this can happen or whether it's going to happen or not. And whatever the awful thing is, or at least one of the parties thinks it's awful, it can't be undone. You can't unring a bell. You can't untell a secret, so to speak. And so this is done in a very short period of time. And a TRO only remains in effect for a very brief period of time. And then there's a subsequent hearing, which is the preliminary injunction, which is a more robust process, and the court hears more evidence. And if the court grants a temporary restraint or preliminary injunction, then that's going to stay in effect usually until trial, which is oftentimes a month, sometimes a year away. So we're at the TRO stage in this case. And so the court has to make a really quick decision within days, probably. So the court does issue the TRO, or perhaps they issued a TRO and then issued a preliminary injunction. So Redmond and Quaker Oats, the parent of Gatorade, appeal saying, we don't agree with what this judge did, please undo it. Well, the Court of Appeals agreed with the judge and said, no, Redmond can't work for Quaker and he can't reveal the secrets. And you can see that at this point, since he left PepsiCo in sometime in '94, this matter percolated for many months, and it may have been, over a year. We're just not sure. You don't need to know the name of this case or its holding, but you can see how Redmond was probably taken aback. I didn't think I had a non-compete, he probably thought. And in some sense he didn't, but he really did. So what are the arguments that PepsiCo would have made in this situation? This is my guess as to the type of arguments that it would have made. It would have said, listen, Redmond knows what our plans are in terms of the, I don't know what you call Gatorade type beverages, but the Gatorade Powerade type market. He knows what our price points are going to be. He knows what our marketing strategy is going to be. He knows what our flavors are going to be. He knows the particular, maybe we're planning on adding electrolytes to ours. Maybe we're thinking about adding vitamins. Maybe we're thinking about adding protein. Maybe we're thinking about making it low-cal or caffeinated. Or we have some plans that he knows about. Well, if he goes to work for Gatorade and Gatorade's sitting around the table saying, boy, should we develop a carbonated Gatorade product? And Redmond knows that that's exactly what PepsiCo is planning on doing, and that they've done market research that shows this is a tremendous opportunity, and lots of customers really like the idea of a carbonated Gatorade type beverage. Well, what is he supposed to say at that moment? Should he pretend like he never saw that report? Should he pretend that he doesn't know that PepsiCo is weeks away from releasing this carbonated Powerade drink? Well, if he doesn't reveal it, that's going to be weird from Gatorade's perspective. What? You knew that this was a market niche that was hot to be grabbed, and you didn't tell us about it? But on the other hand, he would invariably be revealing the confidential information. So he's kind of darned if he does and darned if he doesn't. It's not really possible when you're an executive to pretend you don't have information. You could say, well, Redmond could have caused Gatorade to develop its own survey or its own study customer survey. Well, you could do that, but that really has the same problem too, because after all, Redmond knows what type of survey to do. He could say, well, we knew that customers didn't like the idea of caffeine in their Gatorade, so I'm not going to ask for that survey to be done. We know that they don't want electrolytes in their Gatorade, so I'm not going to ask that survey to be done. What I'm going to ask for is that the carbonated survey be done, because I know what the results are going to be, right? And so he's only ordering a survey because of that pre-existing knowledge that he has. And so it has the same problem that PepsiCo was worried about otherwise. So you can see how poor Redmond is kind of at a disadvantage. The interesting thing is the PepsiCo ended up buying Gatorade, and so now Gatorade is under the PepsiCo umbrella. And so the one person who can't work for Gatorade also can't work for PepsiCo. I mean, he could, in theory, work back for PepsiCo, but once you get in litigation like this, bridges are definitely burned. So it's funny, if only he had stayed at PepsiCo a little longer, he might have been able to switch on over to Gatorade. But unfortunately, it didn't work out that well for Mr. Redmond. Okay, so now we're back to a couple of scenarios that we're going to do about non-competes. So Mary works for a restaurant, and she's required to sign a non-compete agreement. The agreement requires that she not work as a chef for any other restaurant or open her own restaurant in the whole United States, all 50 states, for the next 15 years. Very, very extensive and lengthy element. A Texas court would not find that reasonable. A restaurant, especially if it's just a one location restaurant, again, probably a 25 or 30 mile range would be reasonable. Certainly no more than a 50-mile range. And again, I would say about 2 years would be reasonable in this situation. Both of these limitations are excessive. So not going to support that one. Here's another one. Carl is an architect. He works in Plano. He signs a covenant not to compete. And it says he can't work for any competitors in the state of Texas for 1 year after his employment with the company ends. When the employer finds out that Carl isn't working for himself, it terminates Carl. Again, wouldn't even need a non-compete to terminate Carl under those circumstances, because again, we're at will employment, so that would be perfectly fine for the employer to do so. And so he goes to work for architect in Frisco. Obviously, Frisco and Plano are definitely in the same architectural market. Under these circumstances, Splendid Infrastructure would have seems to have a very enforceable non-compete because the new job is so close to the old job, and the non-compete was just for a year. Now, you could argue that covering the whole state of Texas is too extensive. I don't know enough about the architecture industry to know if that was too broad or not. What courts oftentimes do if something is too broad, either in terms of the number of years that it covers or the geographic area, is the court can chip away at it and reform the contract. Let's say it called for 4 years. The court might say, well, I'm going to limit it to 2 years. Sometimes courts will throw the whole thing out, though, so you never know. So that's one of the reasons you don't want to have a really egregious one-sided non-compete that really favors the employer, because the court may say, I'm not going to force any of it if it's so unfair. So you want to have some kind of rule of reason in this place. And so in this case, the court would probably say, well, the non-compete isn't so unreasonable. After all, it was just for a year. And architecture, people do build things in other locations. So I think the state of Texas is probably a reasonable range for that, or maybe just North Texas. But after all, this person just moved a few miles down the road to Frisco, so I think it should be enforceable. So I think more likely than not, the court is going to enforce the non-compete for Carl. Even though Carl was dismissed, that's not going to make a difference. Okay, so let's talk about the Uniform Trade Secrets Act. Almost all states have some type of statutory protection that permits employers to keep its secrets. Even in states that don't have a statute, though, the common law would provide protection. Texas is a signatory to the Uniform Trade Secrets Act. We won't talk about uniform acts in this course, but except I'll say very briefly, it is a statute that each state has the option of agreeing to or not agreeing to, and Texas has agreed to it. That's the uniform part, is that it's available for all states to ratify, and a state can choose to ratify it or not, or a state can take that document and make some changes to it. And of course, the idea is that secret information is a business secret. Kentucky Fried Chicken relies upon those 11 herbs and spices. Coke relies upon its formula. And so if somebody's formula became commonly known, it would lose a tremendous asset. Now, the information has to be truly secret, so it can't be something that is widely known. And it has to have commercial value. It has to have real value. So, for example, if let's say that McDonald's decided to come up with a new sauce called rotten grapefruits. And honestly, no one ever requested rotten grapefruit sauce. And it was discontinued a month later because it was just so awful. The few people that were curious and tried it, didn't like it at all. Well, the formula might be a secret, but it doesn't have any commercial value to McDonald's to have that kind of sauce. And so the company would need to show that it's truly maintained a secret, and the company goes to significant effort to maintain a secret. and that there is an economic value for the company. And so these are the things that the Uniform Trade Secrets Acts protect: formulas, patterns, compilations, proven devices, methods, techniques, processes. And if it's misappropriated, that would arise when it is disclosed in some non-official way. I sell the information, I'm an employee and I sell the information for my own benefit, or I start my own business and use that secret information. And the person, of course, who shares it improperly acquired the information, or is at least improperly using that information. So obviously, under the statute, the company that has a secret can sue the person who took and misused that secret for money. It can be lost profits of the company that correctly owns the secret, and also any profits that person who stole it gained from using that information. We already talked about the doctrine of inevitable disclosure, so I'm not going to go over that anymore. There's a federal law called the Economic Espionage Act, and that actually makes it a crime to get involved in this type of behavior. It is a crime to steal any trade secret that benefits a foreign power, as well as any theft that is for commercial or economic purposes. So we've talked about PepsiCo. I'm not going to spend any more time on that. And now we have completed our fourth unit within this module. We talked about in the course introduction. We talked about the definition of a worker. We talked about the definition of an employer. And now we discuss the situation of non-competes and trade secrets. So I have a few parting words to give you before we end this presentation. It's so important, especially when you're in-house or when you are working for a law firm and your client asks you to do this review, to carefully consider whether workers have been properly classified as employees or independent contractors. It's going to be safe to classify an independent contractor as an employee, but the reverse is what's going to be dangerous. This can be very, very costly. Hiring an independent contractor to do work is not necessarily safe, because even though you don't have to worry about, a true independent contractor, you don't have to worry about the employee taxes and things like that. If they make a mistake, as your agent, the company can still be on the hook sometimes. If you decide to use temporary agencies or staffing firms, be sure that you look at those contracts very carefully, and that the staffing firm you use is very ethical and law-abiding, because whatever things they do, you are going to probably be responsible for. And then if it's appropriate for your business or for your client's business, you can certainly consider things like non-competes and NDAs to advance those interests. And you certainly want to counsel your clients to be very conscientious about maintaining trade secrets. I hope that these presentations have been helpful for you in advancing your understanding of the nature of employment relationships. I thank you for your attention, and I hope you have a wonderful day. As always, if you have questions about this material, please don't hesitate to stop by my office hours. I would be delighted to talk to you about these topics in more detail. Thanks again. Bye-bye.